Hi, welcome. Today we're talking about what to expect at a consultative examination. And this particular consultative examination I'm referring to is the physical one. Most people in my areas anyway tend to get scheduled for one by the SSA. The good news is the SSA pays for it. Bad news is you might find it less than thorough. You might find it with a doctor who does not specialize in your impairment at all. That's a complaint for a different day. But anyway, you have to make the best of these things because you do kind of have to go. I think if you don't go, you're going to get a denial because they don't schedule them unless they have a reason. I mean, they are spending the money. So the reason is generally that your provider's records were not all that we'd like them to be. So sometimes this can be, let's say it's on the fence, the consultative examination, more rarely, but I see it happen, tips it over in your favor. I'd say that's not really the usual, unfortunately, but so let's get to it. You have to go to it and you want to give the best presentation. It might not really affect whether you win this round, but it will. The things that are in it are going to be with your case if we go to an administrative law judge. So what you do and do not do, and how open and frank you are about your physical problems, and if you have mental challenges as well, which I'll get into in a minute, but they're going to be depicted in here. So we can use that potentially later to show the judge why we think the underlying denial should be overturned. So let's get to it. I have the in front of me, just so you know, when I'm looking down, I'm looking at something I provide my clients so they know what to expect when they go to a consultative examination. And I thought it would be nice for some of them that don't prefer to read to be able to just hear it. So I'm going to try to go through it pretty thoroughly. I just don't want to make it too long. It's like a 2-page document. So I'm just going to try to skim over the important things. So one thing to know is that consultative examinations are usually very short. They're not getting paid a lot, so they don't probably want to spend a huge amount of time. I just want to get right to the crux of the matter. Sometimes they're very thorough. Sometimes they help us a lot. Oftentimes they're just something you have to deal with, and you don't want what you do to hurt your case in the long run. So just kind of focus on the end goal without getting too frustrated. The biggest takeaway I'd say is that you are being observed potentially from the time you approach the front door of that building to when you exit the building. Because a lot of times we can see notations about observations that are not just what you would probably expect. But then when you're walking in, and if you normally, or if you feel pain, you were just sitting in the car for 30 minutes to get there and you feel a little hobbly, or you would be walking with an antalgic gait or a limp, or you do normally, now's not the time to cover it up and act like Mr. Big Man or Superwoman. Okay. You have to be very revealing of your issues. I know we're often used to covering them up. We did in the workplace, right? How long were you working with pain? And then you finally went out. We're private people. We don't like to wear things like that on our sleeves. But you have to not be so covering up, because this is all about evidence for your case. So try to put the pride beside you, somewhat, at least for this half-hour exam. They're going to watch you and probably comment on it. I think they might be asked to. Whether you can get up from a sitting position without difficulty, without struggling to push yourself up from your chair, from sitting to standing. They might have it from standing to sitting, because sometimes that can be difficult. So if it's difficult for you, or you do it a little nervously, try not to totally act like you can do it no problem and flop into the chair if that's not the case. Again, don't try to make yourself look like Wonder Woman or Superman while you're in there. Just be yourself, with the exception of don't let your pride ruin your exam. The examining table is always noted, whether you could get on and off the examining table with or without difficulty, with or without assistance. Sometimes also, whether you could change your clothes without assistance. And what's funny with that is usually we're alone. So I don't know how they could even comment on that, but I'm just telling you, this is what we see. They will probably have you squat, and they're going to check out whether you can squat, to what degree you can squat, whether there's pain. Again, if it's painful, be clear at what point it gets painful. Don't let it keep going until it's agony. It's important for them to know when it starts to hurt, because you're only squatting one time. And if you don't look like you have any issues with it, you could be deemed to be able to squat all day long, which there are many jobs that would accommodate that or ask for that, and you'd be able to do it. So if squatting is an issue, you need to be clear. Same with bending, walking heel to toe, standing on your tiptoes, standing on one foot sometimes, but not always. They are going to know whether you walk with that intelligent gait we were talking about, whether you have a limp. So even if you might be embarrassed by it, it's not the time. If it is, just be yourself. Because if you are telling your doctors that it hurts and they're noting an intelligent gait, and then you go to this exam and you're covering it up, what is that going to represent? If you normally have a cane and you feel you need one, now's not the time to be like, well, I can make it from the car in there, and if I hold the door, I won't need my cane, and then I'll just kind of really carefully go. Bring your cane. It's not that. And I would say that with every doctor appointment, if you need a cane, you need a cane. It is not wise to pretend you don't for those moments. I don't think you should be going without your cane if you need it at the supermarket, if you go there either. But right now we're talking about the consultative examination, but this would also obviously apply to your regular doctor appointments. They're going to be probably doing range of motion testing. So if you have limited range of motion or pain on certain motions, don't wait until it's excruciating. I look at it this way: the second you feel something that you shouldn't feel, if you didn't have an impairment with that limb, is the second you speak up. Okay. Don't hold off. You're not getting brownie points for holding off. You're not getting a bonus. You're not winning a prize. So just be frank about it. One thing too, and I would almost ask all of my clients, let me know about this when you get done. Were you asked to button something, tie something, or zipper something? Any or all of those? If you weren't, please let me know. If you were, please let me know. And if you weren't asked to do it, were you asked if you could do it? Did the doctor ask you that? The reason why I want to know this is because I see it recorded in these reports that the person could zip tie and what's the other one? Zip, tie, and button. And then when I inquire the client, they were never asked to even do it, to illustrate they could do it, demonstrate, and they weren't asked if they could do it. Hey, by the way, do you have any problems buttoning? This is really, really important for a lot of people, and you might not even realize it. Let's say your big thing is not your hands and your fingering abilities, but you do have issues, like you couldn't do maybe a fine manipulation assembly job of fine parts 8 hours a day because of your fingers. Not the reason why you stopped working, but they would prevent that kind of work. That is really important to get across, for reasons you don't understand probably at this point. But that is super important. So if they're saying you can button, zip, and tie, and they never asked you, and you actually have limitations with that, you need to talk to me, or your lawyer, because that's going to be a problem, because that's then false information getting to the SSA that is not accurate and that should not be in there. And we might want to let them know that something awry is going on there. And because buttoning, zipping, and tying is a big, huge thing in so many cases that you have no idea. Cases that are not the big disability from the perspective of the client is not the hand problems. It's something far more, usually back or walking or something's going on. That's something they need to do to get from point A to point B. But sometimes these buttoning things are going to be the things that are going to clinch a case, or not clinch it. So you want to be super honest about it and be aware if they don't check those things, because then we need to maybe speak up, particularly if they said they did or they didn't. Okay. The biggest takeaway, don't hide pain, stiffness, or other symptoms. Now's the time to be an open book. When you're walking in and out of the office, I repeat, don't pretend you're Superman. Let's see here. I'm scrolling down now. I'm on page 2. Sometimes they're going to ask you questions about what you do day to day, whether you can do chores, which kind of chores, etc. And we like to always show our best selves, right? I get it. Sometimes we'll just say yes to a question. Like, for instance, if you ask if you can do household chores, yes. Well, you just said yes, and what you neglected to answer is, and I would suggest you do so, if you only do very light chores, if you only do them for a few minutes at a time, because then you got to go rest, or you don't dare do it longer because pain will start to build up. If you do them only very infrequently, yes, you do them. So your answer, yes, is true, but it's illustrating a non-reality from the perspective of the listener. So you want to almost, if you're going to say yes, because it's true, you do them, and most people do something, you want to be clear on how limited that is, whether they are only very light ones, you only do them very infrequently. Perhaps you do a job that normally takes 30 minutes, but for you, it takes all day because you do 5 minutes here, 5 minutes an hour later, 5 minutes, 2 hours after that. So you're going to want to make sure those things are clear, all those limitations. If your day is comprised of frequent lie down breaks because your pain starts to grow from being in an upright working position, it could be, walking from point A to point B in your house, doing those few dishes, getting in the car and going to the doctor. Those are work postures that when we have certain impairments, just being up and doing them for 2 hours causes an upscale in our pain. It could cause swelling of our legs or feet, depending on what your impairment is. If you do lying down and elevating your legs during the day, 1, 2, 3, 4, 5 times, I suggest you let the doctor know that that's something you need to do to mitigate, so that you can then go do something else later or the next day, so that you bring yourself back to baseline. Really, really, really important. So I'll expect that when I read the report, if that's your case. Bring your medications. They ask for that in the letter, but maybe you don't read the letter that they send you. He's going to need to know what medications you're on. He's supposed to know. If you are there for a physical impairment that you've alleged, but you also feel depressed or have anxiety, and even if you haven't alleged that on your SSA form, maybe you never even told us about it, but if that's something you experienced, share that with him. Okay, let that be known. It's something that you should be telling us as well, your lawyers, but sometimes you forget, sometimes you don't even know you have it, and it's one of those little things that just kind of fog around you sometimes. Bring that up, let him know, or her. And if you have new impairments that you haven't shared with us, it could be things that you never even thought of. It could be the gout in the big toe, or whatever it is. Maybe bring a list. But if you have new impairments that you haven't gotten around to telling us, and you think about them, tell them then. And then, when you're done, give me a buzz and tell me, or your lawyer, whoever that may be, because there's going to be things that we're going to want to advise you on with regard to those new things. So the bottom line is, you really do have to go to the consultative examination, and you can still expect statistically that you might still be denied based on numbers at the early stages. Doesn't always happen, but there is not I would say always plan for the worst and hope for the best. The reason for the important information about what to expect at your consultative examination, and what you need to make sure you relate to the doctor, is really for things almost beyond the consultative examination. Sometimes it actually affects the case at that moment, but more often than not, it's going to be more relevant later. So keep that in mind, and please try to follow these advices. it's only going to help you. Okay. I don't really have more details to share with you on this here. But if you have any questions, you can call me, email me. If you're my client, you know how to reach me, go through the portal, or what have you, and maybe we'll Zoom about it too. So anyway, for those of you that clicked to learn, I hope you learned something before you head into your consultative examination. And good luck with your cases. And I will hopefully see some of you later.